Welcome to the Probate Nation. Probate is a process to transfer ownership of probate assets to the beneficiary of a deceased person. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine train, probate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets are delivered to the decedent's beneficiaries. Some probate train rides are short, while other probates seem to never end. Our show this evening continues the discussion we started in an earlier show about the probate and qualification process at the Fairfax County Circuit Court. Tonight we will look at some of the common probate and qualification issues, the Virginia small estate probate process, and how money can be transferred to non-residents without the need of a formal probate. Then we will work through a series of common probate scenarios that the probate office is often presented with and learn how to probate each situation. We are pleased to have with us this evening two members of the Fairfax County Probate Office. They will serve as our guide as we continue this discussion. Our first guest is the manager of the Probate Division. Prior to joining the Probate Division, he worked in public services, civil docketing, and case tracking divisions of the Circuit Court. Overall, he has been with the Fairfax County Circuit Court for 12 years. He is a graduate of George Mason University. Joining him is a senior probate clerk who has been with the Fairfax Probate Division for over 6 years. He has a master's degree in law from Pune University in India and is a certified paralegal from the Paralegal Institute of Washington, D.C. Prior to joining the Fairfax Circuit Court, she was a practicing attorney in India, where she drafted estate planning documents and filed testamentary petitions in the Bombay High Court. Please welcome Jason Pardo, Probate Division Manager, and Archana Kawarkar, Senior Probate Clerk. Guys, thanks for coming back.
Thank you.
All this brain power sitting next to me. I feel like I should have a couple of case files in front of me so I can ask you guys questions. Well, Jason, let's talk about some of the common probate and qualification issues. Tell us a little bit about the common issues that you folks run into during an appointment that either delay or prevent the admission of a will or document to probate.
Yeah, something such as the customer forgetting to bring the original death or certified death certificate. They'll just bring a photocopy. That will delay things.
Ouch.
Yes. Also, the original will. So we do need the original will. A photocopy will not be good enough. So if you bring a photocopy, that will also delay things. Those are two of the main issues that we see.
Sometimes we have, if the self-proving affidavit's incorrect, it may be an issue as well.
Oh yeah, absolutely. That also could be an issue if it's not self-proving like you just mentioned. That is something that would require a deposition and, like you said, delay. That would delay the
And of course,
process.
they have to pay the probate tax at that time. So if they don't have the money to do that, that could be a problem too, I suppose, right?
Yes. In order for us to complete the qualification, we do collect the fees at the end of the appointment.
Okay. Now, what are some of the common issues that probate clerks run into during the appointment that prevent or delay the qualification of the person who wants to qualify for the document that's been admitted?
Right. Bonding could be an issue. So if you're qualifying as a representative and if surety is required on the bond, you want to be pre-approved, because if you come into the office and it turns out you're not bondable, that will delay the qualification process.
Okay.
That's a big one.
Somebody might be a non-resident. Is that can that be a problem?
If you're a non-resident and you don't have a Virginia resident agent, yes, then at that point it would delay the issues, because delay the qualification just because we need that resident agent either present, or you'd have to have a notarized form with you to bring to the appointment so we can complete the qualification. Okay. But yeah, that also could be an issue as well.
So what if I forget my driver's license and I don't have any photo ID? Is that going to be a problem too?
Unfortunately, yes. We would like to take you at your word, but
who you are.
Exactly. But we do need to see some sort of form of valid identification. Correct.
Okay. So there are a bunch of things that I know. There's a whole checklist of things that you're supposed to bring with you that you guys have posted on the website. So I think it's a good tool that folks can go to help remind themselves about things to bring, because you don't want to waste your time, coming to the courthouse and find out you got to come back again.
Definitely.
So let's talk about Virginia small estates. Okay, so Jason, what is considered a small estate in Virginia?
So in Virginia, a small estate is where the personal assets that were left in the decedent's sole name are less than $50,000. So that does not include real estate. And again, if the assets are less than 50,000 in personal, then that would be considered a small estate.
Okay. Now, Archana, is qualification necessary if the small estate statute applies?
No, qualification of a personal representative is not necessary so long as the decedent's solely held personal assets do not exceed $50,000.
Okay.
But if there is any will, then the will needs to be admitted to probate.
I think that's one of the things that people don't recognize, that actually in the affidavit itself, you have to make an affidavit about whether
Correct.
or not there is a will and if it's been admitted.
That is correct,
So
yes.
you want to make sure you get that
That is
will
a requirement that before they use a small estate affidavit, any will needs to be admitted to probate, and they can schedule an appointment to come in to probate the will.
Sure, and they need to check that checklist to make sure they bring all the right stuff with them. So, now, how can a small estate be administered in Virginia?
So in Virginia, some banks and financial institutions that are holding the small asset are willing to pay out or deliver the asset to the designated successor upon presentation of what is called a Virginia Small Estate Affidavit. And it is an affidavit signed by all of the successors of the deceased, which the bank is willing to accept in lieu of a letter of appointment or the certificate of qualification naming the personal representative of the estate.
Okay, so it is a very good tool.
It is
but
a-
there are some things you've got to take care of in order to be able to use that tool. Now, what inquiries must a customer make before calling the probate division about the small estate affidavit?
Yes, so the customer must have some preliminary information as to what the guesstimate of the decedent's solely held personal assets are. They must find out with the bank or financial institution that is holding the asset whether they would be willing to accept a small estate affidavit, because some banks, according to their policies, may still require a letter of appointment or a certificate of qualification. And the third important thing is that they need to know whether the decedent died testate or intestate, with a will or without a will.
Okay. I know it can be kind of challenging sometimes with the banks to have them actually tell you how much is actually in the account.
Correct.
And whether or not the account has a TOD or POD designation.
Right.
And so sometimes you go up and you get qualified and then you don't need to. So
Right.
it's unfortunate. Jason, let's talk a little bit. How does the family actually gain control of an asset in a small estate that passes by will or without a will? How do they gain control of that asset?
You could two ways. It's something simple as kind of what Archana was mentioning. If the estate assets are less than 50,000, you could use that small estate affidavit.
Okay.
And that's again if the company or entity that you're dealing with is willing to accept that. Otherwise, if qualification is necessary, you'd actually have to qualify as representative of the estate in order to get access to said account.
Okay. Now, does the probate office actually prepare the affidavit, the small estate affidavit?
No, we do not prepare the small estate affidavit. It's a fill-in-the-blank form, so we will give the form to the individual, and it's their responsibility to fill it out, get it notarized, and present it to the company that they're dealing with.
Okay. Let's talk a little bit about the transfer of money of a non-resident decedent. We have a lot of people who are not resident of Virginia who may have an asset like a bank account sitting here in Virginia. Okay, so let's talk a little bit. You know, if a non-resident owned a small bank account in Virginia, does the bank account need to go through probate? Non-resident, and do they need to go through probate to probate that bank account?
It just depends on the situation, and if there's a representative, non-resident who qualified in a different state, for example, well, that person should be able to get access to that asset that's in Virginia. So with his or her certificate of qualification that they got from that different state, they should be able to get access to that Virginia asset. So there's no need to actually do something necessarily with Virginia.
And I think the big threshold question, I think, is how much is there. So if it's less than 25,000, then you can use that certificate as a non-resident fiduciary, and the banks may very well be willing to pay the money over to you. If it's more than 25, then there's some additional requirements, I understand, in order to be able to use that to get access to that. Now, Archana, is probate necessary to deal with Virginia real estate owned by a non-resident decedent?
Depends. This question can be answered in a situation where there is a will and in a situation where there is no will.
Okay.
So if a non-resident dies leaving real estate in Virginia and has a will made, then the will have to be admitted first in the county of original jurisdiction where the person last resided.
Okay.
And then an exemplified or a triple seal packet must be requested from the county of original jurisdiction to be recorded in Fairfax County where the real estate is located.
Okay.
This is called an ancillary probate, in other words.
Mm-hmm.
In a situation where there is no will, the non-resident's personal representative or an heir at law can file a real estate affidavit in Fairfax County where the real estate is located to transfer that affidavit to the heirs at law.
Okay. So it can be a little bit challenging because without a will, then the laws of Virginia would govern how that real estate passes.
Correct. Absolutely correct.
So, well, we have some time left in this particular show. We want to spend that going through some common probate situations. And we're going to show up on the screen some of these facts as we go through a few of these different situations. And then we're going to have Archana and Jason kind of walk us through some of the things that they would see happen or how they would respond if presented with this situation in the probate office. So the first situation we have is a husband and wife, first marriage for both of them to each other. They have children only from their marriage. They own all bank accounts jointly, own their marital home in Fairfax County jointly. All retirement accounts have beneficiaries named, so fairly typical situation. Husband dies with a will, leaving his wife as his sole beneficiary.
Okay.
So everything's held jointly. All the beneficiaries are named, and he has a will, and he names his wife as his sole beneficiary. So the question is, does the wife need to do anything with the Fairfax probate office? Archana?
Just as you mentioned, if everything is jointly held with rights of survivorship, all accounts are jointly held, then the wife does not need to put anything on record with the Fairfax County probate office. If she wants to record the will by choice, then she has an option to schedule an appointment and come to the probate office to record the will. But this is a perfect estate planning situation where everything jointly held, the wife does not need to do anything and can avoid probate.
Okay. And if she does come to the office to actually put the will of record, will she pay a probate tax at that point?
No, as there will not be any assets that require to go through probate, there will be just recording fees that will be assessed
So
and no probate tax. So
That's usually
yes,
less than $50 or so, I think.
that is correct. Depending on the number of pages in the will,
Sure.
yes,
Sure.
approximately around $50 to $60.
Sure, sure. So the will, when you put a record, actually is a way to sort of put in the land records the fact that the property is owned 100% by the surviving spouse.
Correct.
Let's take a look at situation 2. It's exactly the same as the first situation, but we're going to add one thing. Husband and wife owned beach property jointly with the right of survivorship down in Sandbridge, Virginia. Okay, does wife need to do anything regarding that Sandbridge property? Archana?
If husband and wife own property jointly in Sandbridge, which is another county, and it happens to be in Virginia, then again, because it's with rights of survivorship, the wife will not have to do anything. But if this property were not jointly held with rights of survivorship, then the husband's property will have to be recorded first in Fairfax County, because that would be the county where he last resided at the time of death. And a certified packet would have to be requested from Fairfax County to be recorded in Sandbridge County so that his share can pass over to the beneficiaries in Sandbridge County, and so that that county has notice of his death.
Gotcha. Okay. All right, let's continue with this sort of fact pattern, okay? Let's go to the third situation. Same as above, same as our facts. So everything's held jointly. We have property in Sandbridge as well as in Fairfax County real estate. The husband owned one bank account in his sole name, and the value is less than $25,000. Does wife need to do anything with the Fairfax probate office? Jason?
It just depends on what the bank needs. If the bank is willing to accept a small estate affidavit, then the wife would just need to come or schedule an appointment with our office to just record the will only and not qualify as executor of the estate. And that's assuming she is the named executor under the estate.
Sure.
If the bank requires a certificate of qualification as executor in order for her to get access to the bank account, then at that point, yes, she would have to put the will on record and qualify as executor of the estate.
Okay. Now, is there some time limit that we have to wait before we can actually get that small estate affidavit?
Yes, 60 days. We cannot give the small estate affidavit out until 60 days have passed from the date of death.
And if the bank requires a certificate of qualification, then we're going to have to go through the formal process of getting somebody qualified.
That's correct.
Okay. So we do have to have communication with that bank to figure out what they might want and hopefully convince them to take the easier route as opposed to the more complicated route.
Absolutely, absolutely.
Let's go to the fourth situation. We're going to start a new set of facts, okay? Situation 4, which should be on the screen for our viewers. So first marriage for wife, second marriage for husband. So husband was married previously and now he and wife are married. They have children from their marriage. Husband had no children from the prior marriage. They own all bank accounts jointly. They own their marital home in Fairfax County jointly. And all retirement accounts have beneficiaries named. And husband dies with no will. So, does wife need to do anything with Fairfax Probate Office?
Just based on the situation, if the husband did not have any solely held assets, does not sound like there's a requirement to actually come into probate and put anything on record. So it all depends on the situation, and based on this one, if he did not have any assets solely in his name, it doesn't sound like there's a requirement to come into probate to put anything on record.
Okay, and if she wanted to, so the land record would reflect that she owns the property, she could come in, make an appointment, and then record a list of heirs?
Yes. Yeah, if just with no assets, if you want to just record a list of heirs only, yeah, you can definitely do that.
Because he has no will, so under the intestate laws, since the children are all from their marriage, then she, under our Virginia law, she's entitled to 100% of the assets.
She would be considered the sole heir.
Sole heir.
Correct.
Correct, okay. All right, let's take a look at situation number 5. Same as above, again, second marriage for husband, first marriage for wife. But husband does not have a will, and some of the children are from his first marriage. Okay, so does wife need to do anything with the Fairfax Probate Office?
And same situation where there are no assets solely in his name?
No assets solely in his name.
Yeah, again, there wouldn't be a requirement to come into probate because there are no assets in the estate. If, for example, this person did have assets in his name, then at that point, you would probably have to come into probate, put something on record to show who the heirs at law are, which would be the current spouse and all children from both relationships.
Okay, okay. Yeah, because then the division ceases to be 100% to wife. She's no longer the sole heir.
Correct. At that point, the current spouse would receive 1/3 and all children would be 2/3.
Okay. Archie, let's take a look at situation number 6. Husband and wife are married, obviously. Children from their marriage only. All bank accounts are held jointly. Fairfax County real estate is in husband's name only. The husband dies without a will, leaving his spouse as the sole heir at law. So, Archana, given these fact situations, does the wife need to do anything with the Fairfax Probate Office?
No, this is a fairly pretty simple situation because Virginia law allows filing of a real estate affidavit. It is, in other words, called a list of heirs. The wife can file the real estate affidavit to record that her husband has passed away, and this would, in effect, transfer the property to the spouse, as she would be the sole heir at law.
Okay. And I think the goal of the real estate affidavit is, at least in the land records, when we do a title search, they now know that she's the sole heir.
Correct. Yes.
Let's take a look. This is our situation 7. Okay, wife is a widow. She has children. She has bank accounts greater than $50,000 and her Fairfax residence. She dies with no will. Who can qualify to probate her intestate estate, Jason?
At this point, it just depends. If it's within 30 days, all heirs would have to qualify as representatives of
all
the
of them
estate.
have to
All of them, if it's within the 30 days.
Unless somebody waived off.
Correct.
Okay.
After 30 days, any one of the heirs at law can come to our office to qualify as representative of the estate.
Okay.
Now, if all heirs do not qualify that one heir would be required to post surety, or even if it was 2 or 3, say that the decedent left 5 children, if 4 out of the 5 come in, it would require a surety bond. So all heirs would have to qualify in order for us to waive the surety on the bond.
So this is a good example of where the intestacy, we have to be careful, because that's where we get stuck with having to pay for a surety bond.
Correct.
With an insurance company. Let's talk a little bit about, lastly, let's come back to a topic that, of course, is near and dear to my heart since I'm an attorney, which is this process can get kind of complicated, okay? I know there's a limit to how far you guys can help people, because you're not in the business, nor are you allowed to give legal advice. Although you might be a lawyer by training, we don't give legal advice. You're there to facilitate people during this process, but you identify when they need to go talk to a lawyer. And that's my question. Do I need a lawyer, for many of these probate situations we just described? Archana, what do you think?
9 out of the 10 cases you will not need a lawyer, because if the estate is complicated and you do not know how to proceed, in those cases you may need to consult an attorney. But if you're just looking to get the will probated, or come into our office to record a real estate affidavit, or get appointed as a personal representative in a pretty straightforward estate, our staff can help you navigate the process, and we can get you qualified without an attorney. And it's up to you if you want to consult an attorney thereafter to do the filings with the Commissioner of Accounts Office.
Sure. I think the important point to take away from that is that there are legal consequences to some of the things that might be done in the probate office, but you're not in a position to give them advice about what those are, and whether they should do step A or step B. Okay,
yes.
You can certainly show them how to do it,
right,
and certainly can guide them. I think that's important for our viewers to understand, is that that's what you guys are there to help them get through the basics, and as we say, to make the layups. But we're not going to take the in-deep legal issues are not things you would ever take under
right,
give advice about. Well, let's talk. I think there's a lot that's been covered here, and certainly I'm a bit overwhelmed by all the brains that I see next to me. But take a minute to just talk a little bit about some final thoughts or comments you want to share with us, having talked about some of these situations, and especially some of the more efficient ways to probate an estate without getting involved with an extensive, a probate process. So, Jason, how about yourself? Any thoughts you want to share?
So one thing I can add is that we emphasize customer service. Just the whole process can begin with a phone call. Just give us a phone call so that we can see what you have, the situation, go forward, ask you the proper questions so that make sure that you're in the right jurisdiction. We understand that as a customer, you might be coming in from a different state. We're going to try to do our best to make sure that we can get you in at a time that works best for you. We have certain times of the day that we schedule appointments, but we will try to work our best to accommodate the customer in that aspect. Mm-hmm. In regards to real estate, when it comes to a decedent's estate, it's also a good idea to try to clean up land records in terms of the recordings. So if the decedent did have a real piece of real property solely in his name or her name, it's good to actually try to put something on record to show that transfer of said real estate. So it's something that I recommend that they give us a call to schedule that appointment, whether it's recording a real estate affidavit because the decedent died intestate, or to put the will on record, even though that's the only asset in the estate is the real estate, to put the will on record so the real estate can transfer from the decedent to the beneficiaries under the will.
Very good. Archana, how about yourself? What do you think?
I would like to add that if you go wrong in estimation of your assets, and if you do not have the value of the decedent's solely held estate assets, then you can give us the closest estimate that you think right. You do not want to overvalue the assets because there will be a probate tax assessed, and once you pay the probate tax, obtaining a refund from the State Department could be a process. So just give us the closest best estimate, and you can undervalue the assets and then report back additional assets when you gain control of those assets as a personal representative of the estate. And
I think that's a good point to remind people about, because once you qualify, you'll eventually have to file paperwork with the Commissioner of Accounts.
Correct.
And that inventory then begins to set out what you've actually received, because then you understand what you have. And then he'll notify the probate office,
That is
and
correct.
they start to compare what you told them at the probate qualification
Yes.
versus what you report to him. And so if there's a difference, then you guys will issue a letter saying, you owe us a couple more dollars.
Correct.
And so it's better to be a little low, and then we can get it fixed later on once you filed your paperwork with the commissioner.
That is
Good
correct.
point. Very good point. Guys, thanks again so much for coming back.
Sure.
Great information, really down in the dirt with some nitty-gritty stuff, which is important for people to understand. It makes things go much more smoothly if they actually hear someone talk about what situation probably is very likely to be their situation. So again, thank you very much.
Thank
Great
you for
service.
having
Thank
us.
you.
You're very, very welcome.
Absolutely, thank you.
Without a doubt, probate can be complicated and confusing. But what I take away from our program this evening is that Clerk of Court John Fry and Deputy Clerk of Court Gerardo Cullifer have built a strong and talented team at the probate office. And as we learned from Manager Jason Pardo and Probate Clerk Archana Kawarka, all probates are different. And navigating the probate rules at the outset is something the probate office team is there to help you do. Give them a call to review your situation and determine what level of probate is necessary in your situation. And be sure to check all the useful guides, forms, and checklists they have assembled on the Fairfax County Circuit Court website for your use both before and after you start a probate. This brings us to the conclusion of our show today. On behalf of the Probate Nation, we thank you for visiting with us today, and we wish you good luck on your probate journey.